when the court did a search for Michael Padden to get additional contact information to call Mr. Padden to notify him of his tardiness for today's hearing. Big headline from January 4th.
Hi everyone. Adelat Report. You're watching Adelat Report. We bring you real cases. Where we bring you real cases and let's get into today's case. Let's get into today's hearing. Takes a sharp court hearing almost right.
Him up saying prominent Twin Cities attorney Michael Padden. Okay. Don't need to go there. Go here. One 651 9.
Please try again. The number you have entered has not been recognized.
Oh, I am not. Six, 5, 1, 7, 8, 9, 6, 5, 4, 5.
Please try again.
You try it without the 1.
Try it without the 1. I think I've always had to do 1, but we'll see. Not maybe it's a 612 number.
You have entered has not been recognized.
I'm gonna try looking him up. That's what I'm gonna try to do. He's disbarred. Oh.
Not yet.
Well.
Not in Wisconsin. There's a pending case.
Oh, well.
He's only disbarred in Minnesota.
Just in Minnesota. Just in Minnesota.
Track. Almost the defendant walks into court. The defendant clearly under the influence. So obvious that enough even the bailiff takes a second twice. Judge Boyd notices instantly. But instead of reacting with anger or punishment.
Alrighty then. Prominent Twin Cities Michael Padden disbarred. Prominent Twin Cities attorney Michael Padden disbarred. Well, his number is not recognized, so.
Maybe he thinks he's disbarred in Wisconsin, because I know that Minnesota filed a complaint against him in Wisconsin on October 17th.
I'm probably say you need a new attorney. Probably what I'm gonna say. Probably. Do you pay him? I'd probably get your money back. Probably do that. Or ask for it, but sorry. Yeah, because that's the new news is prominent Twin Cities attorney Michael Padden disbarred. Not just suspended, disbarred. Cut, throw, gone. Okay? So, I'm going to give you some time to find somebody else. All right?
For what it's worth, he never filed a discovery demand and we haven't provided any.
I don't know how much you've paid him. You don't have to tell me. But I would try and get that back.
It's a bold choice. She makes a surprising move. Judges would have slammed the gavel. Most judges would have banged the gavel, more charges, stacked on more charges. But Judge Boyd pauses. But Judge Boyd stops, shifts direction, reassesses, and tries.
Just friendly advice. All right, so. Did it take you a lot of time to save what you needed to get to him? Oh, wait. Okay, Miss Kuchera. I'm gonna get it, I promise. Miss Kuchera, why don't you come have a seat up here? Because I'm gonna guess you don't want him anymore and he can't even probably practice anymore. So can we just remove him?
Yes.
And then we can just talk?
Yeah.
All right. We will go on the record.
Tries to bring things back under control. Whether it was an empathy, legal strategy, or smart legal thinking, that's for us to decide. For debate. So what do you think? Was this real accountability with standing?
Matter 24 CM 213, State of Wisconsin versus Casey Kuchera. The state appears through District Attorney Kevin Schmidt in person. Ms. Kuchera appears in person without counsel Michael Padden. The court attempted to call Michael Padden's number 3 times. All times it came back that this number doesn't exist. The court searched for Michael Padden's contact information. When the court did a search for Michael Padden to get additional contact information to call Mr. Padden to notify him of his tardiness for today's hearing, big headline from January 4th came up saying prominent Twin Cities attorney Michael Padden disbarred. So that just leaves me to believe that perhaps he's not able to represent Ms. Kuchera, and Ms. Kuchera has personally paid for his services. So Ms. Kuchera, you have a few things that you need to take care of. I'm going to guess that even hearing that news, even if by some chance, some grace of God, he may still have his license here in Wisconsin, hearing that he's disbarred in Minnesota probably gives you a little bit of angst.
I had just contacted him Monday to remind him that we had court, and he never mentioned it.
Oh, well, kind of interesting. Did you contact him on the number I just contacted him at?
I can give you the number.
I would love it if you could, because I just called this number and it says it doesn't work.
Yeah, 612-669-4542.
Okay, well, that's not the number that I have, and that's not the number that came up. I don't know. And here's the thing. It's up to you and whatever you want to do. If you want him to continue as your attorney, that's your right. If you don't, that's your right too. Completely whatever you want to do. I called the case because you have $1,000 posted because you failed to come to court. So there's $1,000 posted. And what I was going to do was going to see if you wanted him to continue. If you didn't, I was going to remove him, and I was going to see if there was an offer, and I was going to see if there was any restitution. But I'm just going to ask if there is any restitution, because I don't have any disposition supplement. No, there's no restitution here. And so I'm not even sure where this case is going. I don't even know what's going to happen. Off the record, your attorney stated that there, and I'm noticing in my electronic file, no demand for discovery has been done yet.
Yeah, I thought that was kind of odd myself.
Therefore, it's kind of at a still, nothing's happening. So I don't know what you want to do. We can't talk about the case or where it's going or even an offer if you're keeping Mr. Padden as your counsel. He fails to appear. You said you talked to him on Monday, reminded him. You, the client, reminded the attorney. You, the client, reminded the attorney that there was a hearing. That usually goes the other way around. Like usually the attorney has the job of reminding the client, but good for you for being responsible and reminding your attorney who has failed to appear. All right. And again, it's not the court's job to even contact him to appear. He should be appearing, especially when the court gave him permission to appear by video, and he's not appearing by any means. I have Zoom up and there is no appearance. Okay.
Or was it just being too soft? Watching her in that state. You can't help but hard not to wonder if she even realized what was happening around her. When someone shows up in that impaired, a judge isn't just handling a legal case.
Not going to put you on the spot. I'd like to know if there's an offer, but I'm just going to kind of do a quick little turnaround to give you time to think about what you want to do. Maybe talk to attorney or ex-attorney Padden and figure it out. Mr. Schmidt.
Offer would be a ticket for 346,675 sub 1. That's owner's liability for failure to stop after accident, which is according to the bail schedule book, $767.50.
$767.50. And what was the statute?
346.675 sub 1. The owner liability version of it is a ticket, not a crime.
All right. So you can think about it even more. And again, I don't even know what's going through your head right now. Okay. I don't know what's going through your head. You probably have a lot.
Honestly, I'm okay with just going ahead and proceeding without Mr. Padden.
and you want to make the intelligent, knowing, and voluntary choice to remove him as your attorney right now? All right. So therefore, the court will strike him and will withdraw him from the record as your counsel. And so you can understand, and now I'm going to see if you understand the offer that's been presented, all right? You have been charged with the crime, hit and run, as a misdemeanor. This hit and run misdemeanor crime has a maximum possible penalty of up to $1,000 fine and up to 6 months of jail, okay? Mr. Schmidt has made an offer to you to amend it to a ticket, all right? To a ticket for $767.50 under owner's liability for failure to notify of an accident, okay? You have $1,000 posted. That would cover a ticket if that's what you wish to do. I can give you time to think about this and have you come back in the next week or so. We can take care of it here today. Whatever you want to do. I don't want to put you on the spot. This is a lot for you to think about.
I'm okay with just taking the ticket and just going ahead and getting this over with.
You want to accept the responsibility, be accountable for your actions, and take.
They're dealing with legal responsibility and how it all looks to everyone in the reception. Here's the tricky part. And here's the person isn't mentally present or aware of what's happening. If the defendant isn't mentally aware, any decision made in that moment could be legally invalid. It's not about kindness.
For the fine. All right. Mr. Schmidt, formal motion to amend under the owner's liability for failure to notify of an accident.
So made.
Court will grant that. How do you wish to plead? Either no contest or guilty. Doesn't matter. I'm okay with either. No contest. Court will enter a no contest on your behalf here today. I will assess $767.50. You have $1,000 cash bond posted. That will go towards this ticket. The remaining will be sent to the person, the individual who posted it, to the address that they provided, okay?
Yep.
All right. Do you have any questions? Good luck. I'm sorry. Good luck. All right. Thank you. We are adjourned.
Or at that point, it's no longer a matter of protecting the court's process. It's about damage control. This didn't feel like a typical sentence being judge handing down a sentence. It felt more like someone trying to stop a slow-moving disaster. Most judges treat people like just another case number. But Judge Boyd took a second to breath, actually see the person and looked at the bigger picture in a justice system built on deadlines, schedules, and technical rules. Taking a moment to treat someone like a human being is almost revolutionary, almost radical. But it's not weakness. It's the kind of judgment more of in the justice system. Honestly, to be honest, this was one of those rare moments where the system didn't just give up on someone aside. Judge Boyd gave her a chance that most people never get, a real opportunity, a path toward accountability, not just another punishment. Yes, it's risky, sure. But sometimes real change requires when you mix pressure with opportunity. 6 years of education isn't a free pass. It's a challenge with everything. The stakes are high. Now the question is, will she take it seriously or will she fall back into the same pattern? And should more judges take this kind of chance? Or is that just asking for trouble? Asking to be disappointed? What's your take on this? Was the judgment fair? Was the judgment or should have gone differently? Or should it have gone differently? Share your thoughts. Share your thoughts. If you want to see more real life cases, don't forget to subscribe to the channel.